Your Honor, if are you handling continuations at this point, or will you
Not
be
at the
asking?
moment. I will be asking.
Thank you.
And only agreed ones.
Okay.
Edmondson matter. Anyone appearing on that matter? My understanding is it's being set over to May 21, 24 per agreement.
That is agreed, Your Honor.
Okay. All right. So that matter will be set over to May 21.
Your Honor, this is Mandy.
Do you have an agreed continuance?
I believe counsel and I are in agreement that we need additional time on this case.
Okay. What case are you talking about?
233.
Can you just tell me the names? Obviously, Grounds and here we go. Grounds and Bob. 8. Ms. Winkles, are you on here? Oh, yes.
I am. I am, Your Honor. I don't mind setting this over, to be honest with Your Honor. We just got the discovery a couple of days ago. We have gone through it, but I do plan on doing a motion to exclude certain testimony based on your last ruling. In that case, if we could get a 2-week set over, that would work with me. That way we can hear the whole thing at the same time.
All right. Ms. Grounds, are you okay with that? It would be set over to May 28.
Yes, Your Honor.
Okay. All right. So I will go ahead and continue that matter over to May 28. And that will be at 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, on the
Hold on, please. Just a second. Sir, do you have an agreed continuance?
No, Your Honor, but I do have a request to the court. One of the professionals assigned as the reunification counselor has been called away for a funeral this week and is not able to
I'm not
attend today.
addressing anything unless it's an agreed continuance. I will get to your case.
Oh, okay.
Okay. All right. So we have Ms. Long, and then my understanding is there is a notice of appearance forthcoming. Is that correct, counsel?
That's correct, Your Honor. We filed a response, but we did not file an NOA in this matter. And that's my fault. That slipped my mind when I filed the response. And I'm Philip Andrews, and I represent the estate of Mr. Yonich.
All right. So, Ms. Long, this is your request. I didn't know if there was a response to the reply or.
No, there's no response to there's no reply to the response that Mr. Yonich filed.
All right. So with that, what's the plan here today?
Well, Your Honor, to give you an update, Mr. Yonich did submit payment almost in full for one of the debts. The other debt remains unsatisfied. And so my client is asking the court to enter an order for sanctions against Mr. Yonich for failing to satisfy that debt. And our position is that the briefing that Mr. Yonich submitted indicating that this court doesn't have authority to enter an order for contempt, the reasoning in that is misplaced because the order that we are seeking to enforce originally that was entered in the divorce is not a judgment, that's an order of the court. And so it's therefore subject to an order for contempt.
Mr. Andrews?
Yes, Your Honor. Decrees, even absent judgments, are not enforceable via contempt in Washington State. It's got to be something that relates to spousal maintenance, child support, or a parenting plan. It's simply not an available remedy under Washington law. We would be making new law today if we were to find otherwise. The moving party has done what they need to do right now, which is to file a creditor's claim and allow time to work through the process. Mr. Yonich died intestate, and it's going to take a little bit of time to work our way through this. And that's not unexpected. I gave you the timeline in our response about when the estate was opened, when he was appointed, when notice to creditors was published. But regardless of any of that timing, the remedy, such as it is right now for a creditor, would be either via 1196A or via a motion to enforce the decree. This is just not an available remedy that this court can issue. So I wish we weren't here. I wish these expenses weren't made by either party, but they have been. So as a matter of law, I would ask the court to deny the requested relief. And I put in there, and that was before today, that I'm at 4.3 hours. And I would ask that because there was warning and there's case law that this simply cannot be done by the court, that the estate be reimbursed for its fees in responding to this.
Well, this is definitely, Ms. Long, well, let me just say something real quick. This is definitely unique and different. And so Ms. Long, let me just hear from you, your response.
Well, Your Honor, we have attempted to secure payment through the probate, which has been pending for some time. We've received no response to that, no assurances that we will ever be paid. So we did substitute in Mr. Janich for this case. In this case, that was an order that was granted by Your Honor. So he's subject to this court's jurisdiction. If the court feels that it's premature, if we need to give Mr. Janich some additional time, that's fine. But my client would like an order from this court saying that at some date certain in the future, we will receive payment for that debt. That's been ordered by the court already.
So in regard to this, as far as the order's been made, so I don't think doing another order saying that he needs to pay the debt, the claim has been made. It is under the decree that the payment was ordered. But at this point, I would look to the idea, one, I do question at this point the ability to do what you're asking for as far as the contempt. I understand under the statute, it's real clear about the areas that Mr. Andrews has referred to as a contempt action. But as to just a portion of the decree that hasn't been complied with, I do have some questions on that. So I would want to look at that a little further before I do anything. So I think while I'm doing that, I'd like to give some more time to the estate to settle their what they're in the process of doing and look at it further down the line. But I just haven't had the opportunity to really look at the issue that's been brought up by Mr. Andrews. So what I'd like to do is, once you've had more time noted up, I'm not going to order attorney's fees until I see what the outcome is. So I'll reserve on attorney's fees and not order anything else at this time.
Okay.
Thank you, Your Honor.
To come back, Your Honor.
Well, Mr. Andrews, what are you thinking as far as the estate?
Well, Your Honor, here's the issue, and I think that it's one that we all deal with from time to time. I have a client who is not mobile, and so it takes a little bit longer for us to get things accomplished. So rather than waste the court's time, I would say 90 days, which is not unusual in any kind of estate. And again, I point out that the decree never pointed out a time for performance, and it's silent on that. So we're not bumping up against something and ignoring it. It's simply, it could have stated a time for performance and it did not. So if we go to contract principles, we're looking at a reasonable time. So I would say 90 days from now, and we can check back in if there's a need, or it could be the case that all we're coming back for, because the moving party has had the performance completed, and then we're just back here on my motion for attorney fees for coming here for relief that cannot be granted.
All right. And to make it clear, I'm not specifically ruling that today without looking at it closer.
I understand.
And so that needs to be understood, but I would think the 90 days is appropriate and it could come back the first part of August. I don't know if you have a calendar, if you want to set a specific date now.
Well, it's up to you, Your Honor. Counsel and I work pretty well cooperatively, other than this one particular issue we don't agree on. I think we could pick out a time in August and agree to put it on your docket.
Okay. All right. I'm going to be gone for a couple of weeks in August. So how about August 20th?
Let me take a quick look. I can do that, Your Honor.
I won't be available that day.
Okay. How about, are you available on the 27th?
Yes.
Okay.
That works.
Okay. All right. Let's go ahead and just set a date to August 27th then and see where things are at that time.
Thank you, Your Honor.
All right, thank you.
Do we need to create a note for this, or is it just going to be on the docket?
I would ask, since it's so far out, that you go ahead and note it up for that date, just to make it clear. The clerk's making the notes here, but at the same time, because it is more than 3 months out.
Fantastic. Thank you, Your Honor.
All right, thank you. I believe it is.
Matter's ready, Judge.
Present, Your Honor.
Can you identify who that is, please?
Ms. Airhorn.
I do ask, I guess you're on a phone, but I would ask that when you are responding, that you please turn your video on. It's easier to track who's talking on a Zoom call. All right, so I did not see any objections to the proposed orders. Mr. Zandy, did you receive any?
I do not believe we did, Your Honor.
All right, so Ms. Airhorn, I didn't see any objections that were filed. Are you okay to put approved via Zoom on these orders?
Yes, Your Honor.
Okay. All right, I've signed off on the order reappointing guardian ad litem for a child. I've signed off on the child support worksheets and the child support order. All right, we have Mr. Zandy present. Again, if you are present, please turn on your video. And that would be Natasha Colley. Natasha Colley. No response. We do have Ms. Turnbull, is that correct?
Yes, Your Honor, I'm here.
Okay. All right. It doesn't appear that we have Ms. Colley present.
Well, last time we were here, Judge, was 2 weeks ago. We entered some interim orders, specifically allowing the child to be enrolled in the Longview School District. Also gave Ms. Colley 2 additional weeks to see if she would respond or appear. No surprise that she is not. We understand she is living a completely different life at this point. Update the court, still no contact with William, the child. William is going to school now and is enrolled in Longview, which is my client's school district, doing well. A lot better than he was at Y East and Cascade prior. So I think that's the positive. We are asking you to enter the orders today pursuant to your preliminary ruling 2 weeks ago, and also pursuant to my client's requested relief in his initial motion from March. That's where we're at. I do have fresh copies to hand forward to the court for signature. We point out that there is one difference related to the parenting plan. Under the school schedule, we did ask to include that mother give notice if she is going to exercise visitation or plans on doing that with the child, so we're not wasting anyone's time or gas money or putting hopes in the child's head that likely will not occur. So that is included in that in that parenting plan. That is one difference. Also included a contempt order based on my client's motion. I think the court clearly can identify the fact that there was a violation of the parenting plan as it related to decision-making, as this is the case where Ms. Colley decided to unilaterally change the child's school upon another move. And pursuant to that as well, we did ask for a contempt finding, and that's included in the order related to the relocation, again, without notice to my client. So that's kind of where we're at. That's the update. I did not include a specific judgment for attorney's fees and costs. I rather included that in the order for adequate cause that says $1,000 can be reduced in judgment at a future date. Did, however, include civil sanctions and attorney's fees in the requested amount in the order of contempt. So that's where we are. I think everything else clearly identifies my client's position and the issues that have unfortunately occurred since the first of the year in this case.
All right, based on the files and record, I did review everything. The court does find adequate causes established for this case to move forward. The court grants and orders the father's parenting plan be adopted and the proposed child support worksheets be adopted, including the imputing of income for the mother. In regard to the contempt, the court does find a willful and intentional violation of the order when she enrolled the child in another school without notice to the father as required by the parenting plan. And the court further finds a failure to update the father as to the new address. As a result, the mother is in contempt as the court ordered as stated. And as a result of that, I will find that it's appropriate to sign off on the proposed contempt, finding of contempt. So I've signed off on the order on adequate cause, the parenting plan, the child support order, the child support worksheets, and the contempt hearing order. Finding all to be appropriate.
Very well, thank you.
All right, we have Ms. Bliss present. Do we have Nathan West present? Yes, looks like we do. Okay, and I believe the state is involved, but I don't think on this particular matter. And then Mallory Smith.
She was the prior guardian ad litem. I think she just hasn't been removed from the case, but she's no longer active.
Okay. All right, go ahead.
Thank you, Your Honor. For the record, Carly Bliss on behalf of respondent and moving party, namely Melina Davis. This matters before the court on our request for adequate cause and temporary orders. In review of Mr. West's response, it doesn't appear that there's any objection to the finding of adequate cause. Frankly, I think it's pretty obvious. At the time the final parenting plan was entered in March of 2021, my client had custody of Kira, the party's daughter, in Texas. Mr. West had custody of Luke here in Washington. Since that time, Kira has moved home to Mr. West in Washington and is no longer residing primarily with my client. This is a key point as to adequate cause. My client is requesting a modification to the parenting plan to incorporate what has already happened. Kira moved home during spring break in 2022, so it's been over 2 years at this point, but there's been a need for a new parenting plan in place given the conflict between the parties. My client provides for the court that she's essentially requesting a standard long distance parenting plan. She's requesting extended summertime, spring break, winter break, and the like to afford her, extended opportunities to spend time with the children, because frankly, traveling to and from Texas on these parties' modest incomes is just not feasible during the year. So my client's requests are reasonable. She's asking the court, and she's not asking for every single summer. So if you look at her proposed parenting plan, she's essentially asking for alternating years, for alternating summers and breaks. This is reasonable. We were forced to bring this matter before the court due to Mr. West's unreasonable requests. You can see in his responsive pleadings, he's essentially saying, although there's never been any 191 factors, all of a sudden we need a 191 factor against my client, that he is to have sole decision-making simply because she resides in Texas. That's not consistent with case law or statute. He's asking that she pay 100% of all transportation expenses, despite the fact that these parties have split those expenses for the last 2.5, 3 years. This matter was forced to be brought before the court by my client. She was forced to pay attorney's fees in order for me to bring this matter before the court. So we are asking for a contribution of attorney's fees in the amount of $1,500. Again, given the necessity of getting a modified parenting plan in place, as my client put in her declaration, the parties were unable to reach an agreement until Mr. West found out that Ms. Davis hired an attorney. Then he started to come to some sort of agreement, and then he would renege on those agreements. So Mr. West's behavior is why we're before the court today. I did see in his responsive materials, he is asking the court to modify child support. I would note that this was done administratively in March of 2023. Obviously, I understand that the Superior Court has superior authority to override any sort of administrative order, but I would ask if the court is inclined to make any modifications to child support that we reserve on that issue pending further discovery and further disclosure of financials. It's my client's position that this was just done and she is current and paying child support, so there's no need for it. There's been no change of circumstances, there's been no change of incomes. So this time we are asking the court to deny Mr.'s request to modify child support and simply enter the parenting plan that we've provided, which we believe is in both these children's best interest.
All right, Mr. West.
I don't think we have any audio.
I'm not able to hear you, sir. All right, go ahead.
So prior to Melina hiring an attorney, her and I had a communication about the visitation, and part of the agreement was that I would get the tax write-off for the children since they live with me, and I am footing most of the extraordinary expenses for them. When she contacted Ms. Bliss and I received the paperwork, the agreement for the tax deduction was not in there. So that's why I'm asking for an increase in child support, is to make up for that difference in the tax deduction, the write-off that I would get that would help me pay for the extra stuff like the dental. My son has got to go in and have his wisdom teeth pulled. And I spoke with her about that, saying, hey, with this cost, I can't afford to pay for plane tickets and shell out $4,000 for wisdom teeth removal at the same time this year. So I gave her the choice of, paying for the plane tickets or helping pay for half of the cost of the dental work. And that's when she wanted to start modifying papers and stuff like that and everything else. So I also have dental work for my daughter that needs done. She needs some fillings and stuff. And then like my son is in driving class right now that I've paid for all of it. And then my daughter is getting ready to start driving class. This is all extraordinary costs above and beyond what I would consider standard child support as far as the caring for the children. And, she knows this stuff is coming and whatnot. I sent her the price for the dental, and then, she's like, it's too much. And so I checked into other stuff, and I actually ended up revamping my entire dental program. So I pay more out of pocket to get a better discount on the dental itself. And still she's like, well, no, I'm going to pay them direct. And she doesn't understand that, like with the surgery for my son, it's a one-time payment. They don't take payments after the procedure's done. It has to be paid in full prior to the procedure. So, I mean, that's the biggest reason why, I'm okay with the 8 weeks during the summer and whatnot. Most of the visitation stuff I'm fine with. The biggest thing is that, I would like some help with the extraordinary costs, or I would like the tax write-off on the children. So last year she told me I could have Kira this year, and then she filed for Kira anyway. So, she's saying I'm reneging on what I say, but she's also doing the same thing.
Anything else?
No, I don't think so. Not right now.
Ms. Bliss?
And Your Honor, under the final child support order, extracurricular activities, uninsured medical expenses, transportation are all lined out. So to now claim that my client's not paying those, I don't think this is the appropriate venue for that discussion to be had. Obviously, I'll speak with my client about that, but it doesn't sound like there's any objection to our request for adequate cause. It doesn't sound like there's any objection to our proposed parenting plan, so I would ask that those be entered today.
So in regard to I did review the files and record, and based on that, the court does find adequate cause has been established for this case to move forward. In regard to child support, it sounds like maybe there are some outstanding issues that need to be worked on. So I'm going to reserve on that and have that looked at. Sir, that should be addressing those areas that you're talking about as to how much she owes for the extracurricular, for the uninsured medical. All those things should be in your child support orders. So that's why I'm going to go ahead and reserve on it for now to make sure that everything is clear and in those orders. So that can be taken, have a look at that, as well as the tax, who gets to claim the tax exemptions. So that's what's going to be reserved at this time. The parenting plan sounds like there isn't any objection there. So I'll go ahead and sign off on the parenting plan. Transportation will be 50-50 at this point. It will remain. It's the other issues that need to get dealt with. As to attorney's fees, the father will be responsible for 1/4 of the attorney's fees. I don't know what that comes out to be, Ms. Bliss. But the mother has had the benefit of conferring with an attorney, and at the same time, the father benefits in the long run from getting the paperwork done and getting this moving forward. So with that, I will be ordering that as well.
Okay, Your Honor.
Yes.
With the dental expenses this year, I will not be able to afford to put the kids on a plane.
Okay, I've ordered what I've ordered. You should take a look at your child support orders. That part of the medical should be covered in those papers. That uninsured medical and what she owes you for that.
Right. I understand that. The issue is she wants to make payments on it. She doesn't want to make the payments to me, but I have to pay the amount in full ahead of time is what I'm getting at.
So I understand this time you're telling me that she's not paying that. That's not properly before the court today. So if you want to bring that back, that she's not paying the amounts, that's your right to do that.
Okay.
Okay.
So my concern is that not being able to put them on the plane, she's also going to come after me for contempt of the orders because I can't afford half the plane ticket this year to fly them down there for the summer.
Then you may want to consult with an attorney and see what you need to do. But at this time, that's what I'm ordering.
Okay.
All right. So with that, do you want to set it on for the 21st for presentation?
We can do that, Judge. I have the orders largely prepared, but I'll make those changes pursuant to your ruling.
All right. So Mr. West, what will happen is Ms. Bliss will prepare the orders that reflect my ruling. Okay. And then she will send those to you. And if you agree with that it reflects what I ruled, not what you want, but what I ruled, then you can sign off on them. Otherwise, we'll put it on for May 21st at 9 o'clock for a presentation, which means one way or the other, I'll be signing the papers.
Okay.
Okay.
Thank you, Judge.
All right.
Thank you.
I see a notice of appearance from you, but
I think that's because this has been some back and forth that we didn't. We filed the initial motion for that. We've represented Ms. Estabal exclusively to cut down on fees. I think we did withdraw. I can certainly update that in my preparations for today. I did notice that there wasn't a fresh notice of appearance. Long story short, I will be representing Ms. Estabal as we've been involved in this response.
do I have anyone else present on this case? No response.
Which case is this, Your Honor?
Nestabal?
And this is a broken record. This is a case that my office had initially. Ms. Gilmore represented my client. This is one where final orders were entered back in 2019, which indicate Mr. Nestabal was to pay $1,750 per month towards alimony for an extremely long-term marriage in which the parties eventually dissolved that. This case has come back multiple times on contempt for Mr.'s refusal to pay the support as ordered. We're back in that situation, unfortunately, again. He'll make payments here and there and then go extended periods without making payments. He'll then make a jumbo payment in which he thinks, essentially catches that up, and then fall off the face of the earth for a period of time, refuses to pay. Unfortunately, we're in a position now where he's reverted back to those types of behaviors. We provided you with information related to my client and her adult son's efforts to collect on that or nudge Mr. Nestabal into payment, and he comes back, and we filed that with you. Although some of his writing is difficult to decipher, it appears his most current and recent response to that is, I refuse to pay you. I refuse to pay your attorney's fees until you essentially apologize to the grandkids or make some grand overture about how you've been lied. So again, he'll pay, but it's very reluctantly, it's sparsely. And now the most recent conversation is basically, I'm not going to pay you until such time you correct what I perceive are those lies. Certainly that's not appropriate. Certainly that's a willful intentional violation. And he's essentially using the court-ordered maintenance obligation as a means and a method to, again, control my client post-divorce orders, which were entered back in 2019, which shows his willful and intentional disregard for the order. He doesn't appear in court, which is problematic. He doesn't get the message that he's supposed to pay, which again is problematic. I'm in a position now of trying to figure out what the best way moving forward is. You saw in one of the communications between the parties, my client's adult son suggesting maybe we just need an auto transfer out of bank statements or out of bank accounts every month to satisfy that. We don't get a response to it. We need to do something outside of coming back to court, accruing more attorney's fees, more costs, more judgments that he has no intentions of paying. Now, Mr. Nestabal is now 88 years old. He's taken the approach over the past 5 years that, well, I'll pay you if it's convenient for me. Otherwise, I'm going to look for every excuse not to not only pay that, but to make things complicated, unreasonably and unnecessarily so. So we're back. And we're back for by my count, about 5th or 6th time on one of these contempts. He's always found in contempt. He doesn't pay the attorney's fees and costs until his feet are held in the fire. He doesn't show up to court. This is kind of where we're at with this. This is the frustration of my office. This is my client's life, unfortunately, where she's trying to track him down to budget off those payments, which are necessary for her. We are asking for yet another contempt finding. We are asking for the fees as requested in my client's motion. I'm asking that we set up some kind of a method of payment that is going to be consistent and suitable for where these parties are in this stage of their lives. And I don't know what that is. I don't know if that's a lien. I don't know if that is direct payment out of a bank account, but getting him to comply has always been problematic. And so I think the first step in this is, again, finding him contempt, again, entering the judgment as we have requested, and allowing some kind of leeway on finding a mechanism to get him to pay consistently and timely and completely, which has been the issue since day one. I think we need to get a little bit creative with that. I don't know what that is. He's currently living in Las Vegas. There's not a lot of assets that we can draw upon, but there are some that he maintains and controls. I think that's kind of where we are. But again, the basis for contempt is there as he is willfully and intentionally not complied with any orders of this court.
So the court did review the files and record and is familiar with this case. Court finds willful and intentional violation of the support order by failing to pay the support as required by the court order. And as a result of the contempt, will pay a $250 civil penalty and pay $1,000 in attorney's fees for the necessity of having to bring this motion. And the purge can be done by compliance with the court order, which doesn't seem to be the case. As to options, court just is not real clear as to what that might be. So, but at this point, we'll leave it at that.
Presentation, I did not propose an order, but next week or ex parte.
Ex parte is fine, just put did not appear.
Okay, and I'll get that over by tomorrow.
Okay. Gonna get going here.
Thank you.
Thank you. Mr. Gall, are you present? Robert Gall?
Yes, Your Honor.
I apologize. When you first were talking, I didn't recognize your name, but when you said something, I thought, oh, it's that case. Your case is on the 1 o'clock docket.
The 1 o'clock docket?
Correct.
Oh, I was unaware.
Yeah, the clerk looked it up and you're on the 1 o'clock docket.
I was wondering why the other parties were not here. Well, thank you, Your Honor.
Yeah, okay.
Right,
Sorry
bye-bye.
about the delay. Thank you.
Problem.
All right, so we have Ms. Dow, we have Ms. Powers.
And my client, Mr. Soul, is present with me in my office.
Thank you.
And Ms. Ormsby is here by Zoom.
Okay, thank you. All right, counsel, go ahead.
Thank you, Your Honor. This is our motion for temporary orders, and I'm going to start with the easy issues. We have asked that the father be able to use the Dodge pickup and the mother use the Jeep Wrangler. I believe that that is agreed between the parties. And then we've also asked the court to divide the debts. Mr. Soul will be responsible for the truck loan. Ms. Ormsby would be responsible for her student loans. Ms. Ormsby mentioned in her declaration a Lowe's credit card. That's only in Mr. Soul's name. He agrees he'll continue to be responsible for it. And there's a Synchrony credit card only in her name that she will be responsible for. And we agree with that as well.
Okay, great.
The next.
We agree with those also, Your Honor.
Thank you.
The next issue I'll talk about is child support. I think the parenting plan is the hardest issue here, so I'm saving it for last. In terms of child support, Mr. Soul is a heavy equipment mechanic. His gross income is $8,630. His net is $6,833.97. Ms. Ormsby submitted her declaration indicating she started a new job, earning $35 an hour. She indicates she's currently only working 48 hours a month. We asked the court to impute her at $35 an hour, 35 hours per month. We are also asking for a residential credit, but recognize that that's going to be dependent on whatever parenting plan the court orders. Would the court like to finish argument on child support before moving to the parenting plan, or have me jump into the parenting plan?
Go ahead and jump into the parenting plan because it does play some part into the child support.
Okay, thanks, Your Honor. These parties separated in July of 2023. They have one child together, Cohen, who is a year and a half old. He'll be 2 in October. The parties separated in July, and at that time, Mr. Soul lets the court know that initially he had 80% of the nights with Cohen. Beginning in October, the parties switched to a 50-50 plan. In December, they tried a 2-2-3 plan, and in January, they started week on, week off. When they were doing week on, week off, Ms. Ormsby was providing some of the child care while Mr. Soul was at work during Mr. Soul's weeks. Both parents have been very involved. Both parents have been involved in medical appointments. Mr. Soul has attended some of the medical appointments. Both parents have met Cohen's needs. We filed our motion and mailed it to Ms. Ormsby March 26th. Since our motion has been mailed, the conflict between the parties has escalated significantly, and we would assert that that has been at the fault of Ms. Ormsby. We filed a supplemental declaration with the court on April 18th, laying out for the court what happened when the parties exchanged the child on Easter. At that time, when my client went to pick the child up, Ms. Ormsby followed him to the car and berated him about what a bad parent he was. She indicates that my client put his arm up, it touched her. As soon as my client left, she called the police and reported he had assaulted her. I have attached the police reports to the supplemental declaration. The police reports indicate that even Miss Ormsby's boyfriend confirms that Mr. Soul was not trying to hurt her, and also confirms that Miss Ormsby was talking negatively to my client and following him to the car while my client was holding Cohen.
That's not what it says.
Hey, stop.
So we had that on March, on Easter at the end of March. That's when Miss Ormsby began her week with the child. That's when my client began the week with the child. The child was exchanged again on April 7th for Miss Ormsby to begin her week. That exchange happened at the police station and it went fine. My client should have picked the child back up on April 14th based on the pattern that the parties had been following since January. Instead, leading up to the April 14th, Miss Ormsby started texting my client and threatening to withhold the child, and ultimately did withhold the child and said she would not be turning him over on April 14th. Our initial temporary order hearing was scheduled for April 23rd. Ms. Dow filed her notice of appearance, I believe it was on April 10th, and ultimately asked for a continuance. We did not agree to a continuance because Ms. Ormsby had been withholding the child and my client hadn't seen the child since the exchange at the beginning of April. Prior to the hearing, Ms. Dow and I worked out an agreement between the parties, a CR2A agreement, so that when the hearing happened, we put that agreement on the record and agreed to continue the matter to today. That agreement included that Cohen would be turned over to my client on April 23rd, the same day as the hearing, and that he would have him for the next 7 days. The parties would essentially have gone back to a week on, week off, and while my client was at work, Miss Ormsby would be able to watch the child. My understanding was that they wanted to make sure this child was with a consistent caregiver, which would be either one of the parents. After this agreement was entered on the record, my client decided to take a few days off work to spend a few more hours with his child during his agreed time. Ms. Ormsby decided that that violated the agreement that we made. We filed the emails and text messages with the court that ensued after that hearing on April 23rd. And it's clear that Ms. Ormsby was not treating this as a binding agreement, but was treating this as a situation that she could still call the shots and make changes. You'll see that on April 24th, we filed an ex parte order trying to enforce the CR2A agreement, and Ms. Ormsby's behavior continued to escalate that day, going so far as emailing me directly over her attorney's head. And that email is filed with the court, and you see on April 24th, Ms. Ormsby was still making demands to my client that he give her additional time or she wouldn't turn the child over. The child did eventually get turned over on April 24th. My client picked him up. He video recorded on his phone the whole exchange. It went fine. He got in his truck. He drove to Fred Meyer to pick up formula that Ms. Ormsby indicated was needed. And then when he gets back to his house, the police are waiting there, and my client is arrested for assault 2 DV. We've also filed the probable cause statement. My client indicates for you in its declaration, when he left Ms. Ormsby, she was fine. He doesn't know what happened, but she claims that he came back and assaulted her and that she was bleeding from the head. There are now criminal charges pending, and a DVPO was filed by Ms. Ormsby in Clark County. We provided a bench copy yesterday of the temporary order in the DVPO that clearly allows the court to order parenting time for Cohen, and that parenting time is excluded from the DVPO. All of this is really concerning. We see this pattern where we filed our motion and mom calls the police at the end of March and claims that there was an assault. Even by Ms. Ormsby's boyfriend's record, there wasn't an assault. You can see that played out. Then we've got this other exchange. We see Ms. Ormsby sending these text messages, making demands on my client, making some comments about what a bad parent he is, emailing my office directly, demanding more time or saying she won't turn him over. Then we see these text messages that she won't be able to meet him at the police station unless he wants it to be really late at night. Almost like a setup. Then we've got my client doing this exchange and suddenly he's arrested. He's got all of these restrictions on him. When the history has been that both parents have been very involved and regular influences in this child's life. At this point, it is very important that the court appoint a guardian ad litem. These are significant allegations being made. We're also asking the court enter a temporary parenting plan. We had initially proposed a 2-2-3 parenting plan based on the age of this child as a 1-year-old. But given the conflict that has occurred at exchanges, I think it's important that we have as few exchanges as possible. And so I would ask the court to enter a week on, week off parenting plan, set the exchanges at the Ridgefield Police Station, and my client can have a third party do the exchanges for him. Ms. Ormsby has provided some information that this child may have autism. My client was at the last well child check. The child has not received an actual diagnosis. The medical records that Ms. Ormsby provided show that more testing is being done, and that's correct. My client agrees that more testing is being done, but as of right now, there hasn't been a diagnosis. But regardless of if there is a diagnosis, this child does need consistency, and his father has been a consistent part of his life and a consistent part of his schedule. And yet, Ms. Ormsby has kept my client away from him essentially since April 7th. So we are asking that the court enter a temporary parenting plan and a guardian ad litem report. My client is capable of getting the child to any medical appointments during his time with the child. He is an involved father and will participate and facilitate all of that, and can facilitate a regular bedtime and regular routine while the child's in his care as well. Thank you.
Ms. Dell? You're muted.
Sorry, my mouse is a little slow this morning. Your Honor, I would like to point out that my client is still suffering the after effects of the concussion she received at the hands of Mr. Sewell the day after the last hearing. Not only that, the first thing Mr. Sewell did when he was released on bail was to make sure that Ms. Ormsby's phone service was canceled and her telephone number was taken out of service. He's gotten so focused on his conflict with her, he's putting those feelings before his son's needs. The DV incident that the parties that occurred here, for which he was arrested, that occurred. It was an argument about the agreement that they'd made for interim parenting plan, because Ms. Ormsby made that agreement assuming the status quo, that she would be caring for the child during the day while Mr. Sewell was at work, which that's been their most usual arrangement since separation. Mr. Sewell informed us after the fact that he'd be staying home for the week, which might have seemed like a positive act on this part, except that it meant that this year-old child would not see his mother for a week. Ms. Ormsby complied under protest, but she did comply. Her concerns then are still her concerns now. Mr. Sewell has not been the consistent caregiver during the day. He works all day. He can't be. As far as contacting Ms. Powers directly, Ms. Ormsby did not understand, and it didn't occur to me to tell her that once she had an attorney, she could no longer contact Ms. Powers directly. She was responding because she had been, up to the time I noticed in, she had been communicating with Ms. Powers directly. That was not an attempt to sidestep any processes or any authority. This whole situation with the child not being around his mother and spending more time with his father, and that particular agreement for that week, that may not have been a bad thing for another child, but we're talking about a child who, as Ms. Ormsby said in her declaration, potentially carries a genetic disorder that can affect brain development. That needs to be considered together with the issue of potential autism. He's been showing developmental delays since shortly after birth, particularly in motor skills and communication. Mr. Sewell is aware of this. His pediatrician has scored him at least moderate on the scale for autism. He has an appointment with a specialist that's been delayed, but it is occurring this week. But in the meantime, the doctor is looking at the whole situation with the child, and these observable developmental delays, some of the behavior issues that the child has when his environment is not what he expects it to be. The doctor has also made some recommendations about keeping him, some specific recommendations about keeping him on a very regular, predictable schedule, adjustments to his eating and drinking, physical and verbal exercises to help him kind of try and meet some of the milestones that are set for a child's development. Mr. Sewell was very argumentative with the doctor at the last appointment. He is not receptive to Ms. Ormsby when it comes to sharing information about the child's environment and care. The domestic violence incident that occurred the day after the hearing appears to have been triggered by Mr. Sewell finding a suggested routine in the child's diaper bag. He lost his temper to the extent that he put the child in the truck. He returned to the house, knocked on the door. Ms. Ormsby answered the door, and she was physically harmed. The incident at Easter, she and her partner downplayed that. She does not want to get into confrontations with Mr. Sewell. That was clear by the fact that when she contacted the police after the incident on the 24th, she hung up several times. 9/11 dispatched the police anyway, and the police report has been submitted to the court. That was available for you to read. That in itself suggests placing a toddler overnight with someone who can lose his temper so easily, never mind a child who's got developmental issues, who's got some behavioral issues. When they were making frequent exchanges for overnight parenting, the child was having meltdowns at the exchanges. He wasn't sleeping through the night. He was making little or no improvement to his verbal abilities, even when he was being cared for by Ms. Ormsby during the day, especially when he was being cared for by somebody else in Mr. Sewell's home while he was at work. And those frequent exchanges were part of the problem. That's a situation that calls for patience and actual presence, which Mr. Sewell can't provide when he's at work all day. He's going to have to provide a caretaker who's not part of the child's household. When the child was staying, and Ms. Ormsby withheld the child from exchanges for the couple of weeks before the original hearing was scheduled because Mr. Ormsby refused to return the child to her based on their agreement at the time. It was a loose agreement, but it was very clear, and he kept the child for a week instead of returning him. When the child has been with Ms. Ormsby for that extended period of time, he's been sleeping in his own bed, not switching caregivers every few days. He's made noticeable improvements in his verbal skills. He's calmed down considerably so that he can get enough sleep, focus on the developmental exercises. Your Honor, I'm no expert on autism in children. I doubt anyone present here actually could claim to be, but all the available literature is stressing how important it is to address developmental issues, whether they're formally diagnosed as autism or not, as early as possible. Provide a predictable, low-stress environment, especially when a child is so young. This child is just over a year old. At Ms. Ormsby's home, he has his own room and his own bed. It's got rubber flooring to sort of ameliorate some of his motor skill issues. He doesn't have that at Mr. Sewell's home. Ms. Ormsby is just beginning a new job that has her working 2 weekends a month, long shifts 2 weekends a month. That allows her to be at home with the child most of the time. When she's at work, he'll most often be cared for by her partner, who's a member of the child's household. The child will be in a familiar environment. Again, contrast that with Mr. Sewell. He's not at home during the day. He doesn't appear to be working well with Ms. Ormsby for the benefit of the child, especially given some of the developing concerns that they're having with medical issues with the child. It's not because he doesn't love his child, Your Honor. This just appears to be a situation where he can't shift his focus from conflict with the child's mother. This was to the extent that during the period when the child was with his mother for a couple of weeks and before the no contact order was put into place, he made no attempt to contact the child over FaceTime, which is something he knows that the child enjoys. The child communicates with other family members over FaceTime. This is contact. Mr. Sewell made no attempt to do that. My client doesn't want to harm the bond between their child and his father. That's not good for the child. But the child's well-being and his immediate well-being has to come first. If the court's going to order parenting time with Mr. Sewell, we would ask that it be limited to daytime hours only, at least for this temporary order and at least until we get a clear set of directions about what to do about the child's developmental issues. We would be suggesting that maybe 2 hours after work on Monday and Wednesday, and 6 hours every other Saturday. but definitely no overnights at this point in time. We'd ask that it be coordinated with Ms. Sewell's daughter, who is 6 years old and who has a strong sibling bond with her child. Your Honor, Mr. Sewell is denying that this domestic violence incident ever happened. But if you read the police report and you look at the times of the text messages between the parties about when he was going to come pick up the child, the time this incident occurred, the police had what they felt to be solid probable cause to arrest him. So we are asking that the court adopt a parenting schedule that does not include overnights, at least temporarily. As far as the guardian ad litem is concerned, we would not object to having a GAL appointed. I think that this is clearly a case where we do need to have a professional third party take a look at this situation. If possible, we would ask the court to give some consideration to a GAL who has some experience with the needs of children who have neurodevelopmental delays. As far as the child support issue is concerned, we submitted worksheets that show accurate information about Ms. Sewell's hourly income and the schedule that she's just recently received, showing when she can expect to be working. We were indicating 48 hours a month. Ms. Powers asked for 35 hours a month for an imputation. That may have been she may have misspoke there. I think she was probably asking for 35 hours a week. That's not when my client works. She is just getting back into a job in her area of education and experience. She doesn't have anything available that is going to give her full-time work. She'll get there as soon as she can, but at the moment, she can't do it. And at the moment, some of the concerns for the child's care and keeping him with a consistent family member caregiver, I think, take precedence over mom having a full-time job. Again, Your Honor, this is a matter where we're going to have to step very carefully, at least temporarily.
Powers?
Thank you, Your Honor. Just briefly, I am asking that the court impute mom at 35 hours a week, not a month. I believe she is underemployed. She's been a respiratory therapist. She's worked on and off throughout the parties' relationship. So we would ask the court to impute her to 35 hours. Just briefly in response, Ms. Ormsby mentions her phone getting turned off. We have communicated with Ms. Dow about that. And my client did communicate with the phone company in a way that it should not have prohibited Ms. Ormsby from having her own account. Given the criminal no contact order, it was not advisable that they be on the same phone plan and that he'd be able to have access to her phone in that way. Again, talking about the child's needs, the medical records that were submitted don't show diagnoses. My client is aware of the things that have happened, and it was at the last well child check, and disagrees with the amount of concern that's there, but also does acknowledge that more testing is done and there may be more special needs, and he'll support that, but he's waiting for that to really be diagnosed and understand that. Ms. Ormsby claims that she downplayed the Easter event, yet she was the one who called the police, and the police report sets out clearly what happened that day. It's alleged that my client is the one losing his temper and not keeping his emotions under control. Yet when you review the text messages and the emails from Ms. Ormsby, she's the one who appears to be ramping up and acting in a more dysregulated manner. We agree that he needs a consistent schedule. My client can provide that. When Ms. Ormsby wasn't the one providing child care during Mr. Soul's workday, it was Mr. Soul's mom, Cohen's grandma. So these are consistent people in his life who can all facilitate a consistent schedule and wrap around this child and support the help that he needs, whatever help that is. We're still asking for week on, week off. If the court is not willing to do that, we would at least ask that my client have the child every other weekend and do all the child care while Ms. Ormsby's at work. He has the weekends off. There's no reason this child should spend 24 hours in a weekend with a partner. These parties only separated in July. This partner is a newer figure in this child's life. He should be with his dad instead of with a new partner, especially because my client doesn't work on weekends. My client did not take advantage of the FaceTime that Ms. Ormsby recommended. This child is 1 year old. FaceTime would have to be facilitated by Miss Ormsby, and contact with Miss Ormsby has not gone well since we filed our motion. So my client did not take advantage of that FaceTime for that reason. And we just maintain our requests.
I reviewed the files and record and everything that's been stated here. This is a 1-year-old child. The parents need to be the parents and looking out for the best interest of this child, not for your own best interest, but the best interest for the child. And I want you to keep that at the forefront of what you're thinking, what you're doing, how you're acting. Maybe there isn't a clear diagnosis on something at this point, but the reality is that there may be. So you start working with that child now. If there isn't, great. But at the same time, you don't want to have delays because you haven't bothered to step up and be the parent that child needs. So at this point, the court understands that there are allegations and finger pointing back and forth. It's going both ways. So trying to figure out what is going to happen is definitely a question of, again, what's best for the child. Unfortunately, we're going to have to take steps to try to keep the parents apart because they obviously cannot work together anymore for whatever reason, whatever's going on. So what I'm going to do today is one, very, very temporary at this point, and it's something to try to work to keep the parents apart. That child needs both of you. The child wants to love and be with both of you. So you need to figure that out and figure out how your behavior is impacting things, not the child's behavior. So again, if the child does in fact have some basis for special needs, that needs to be put into place. And so this is what the court is going to do. If the child is in fact autistic, then regular changes of the child's schedule is going to be difficult for him. At the same time, trying to figure out that this is a 1-year-old and trying to maintain as much contact with both parents, not just one parent. So you need to look to not only minimize change, but also have an understanding of foods, bedtimes, and every other issue that affects that child. So based on the files and record, the court is going to order the following. 1, the court is going to order or appoint RGL GAL Jennifer Schaefer to have her do an expedited guardian ad litem investigation. I will be doing an immediate order to have her appointed. I direct each of the parties to contact Superior Court Administration to obtain, or your attorneys, to obtain Ms. Schaefer's contact information. Once that investigation is done and a report completed, then the court will be looking to appoint a more long-term guardian ad litem to do a more thorough investigation. So this is for the now. What do we need now to best serve the interests of that child? While that investigation is occurring, the child shall reside primarily with the mother, but it will be the 2-2-3 schedule will be put into place pending that investigation. Fridays shall define the schedules. Since the court is trying to minimize times that the other parents cross paths, the other parent will not be the caretaker of the child. That's why the change in plan schedule. The child shall be exchanged at the Ridgefield Police Department. Neither the mother, father, or any of the significant others of those parties shall be present for those exchanges. For now, the mother shall be the sole decision maker. There will be no specifics as to holidays, birthdays, or any other special day for the time being. The point is to limit the exchanges and maintain the schedule for the child. The mother shall prepare a list of foods, bedtimes, and any other issues that the father needs to know and place that in the diaper bag. I'm assuming there's a diaper bag. There is only to be information regarding the child, nothing else. If the father has special information, he can do the same. The parents will use a parenting app to discuss anything regarding the child. It is only to be about the child. This is intended to be a very temporary schedule. As to child support, the father's income is set at, you said it was $6,833, Ms. Powers?
That was his net, yes.
Okay, so $6,833 per month net. The mother is underemployed and will be imputed at the 35 hours per week, $35 per hour. Credits for overnight shall be given. This will be recalculated if a change of schedule later on. And as far as claiming child for taxes, that will be reserved at this time. Anything I missed, counsel?
Your Honor, can I just clarify on the parenting plan, you said you're adopting a 2-2-3 schedule. When will that begin?
So is there any visitation going on now? I was looking to start effective this Friday.
Okay, there has not been any visitation. So this Friday, my client will get him for 2 days and then back to Ms. Ormsby.
Correct.
Okay. And can the court just set a time that those exchanges will happen?
I didn't know if there was a work time that works best. Usually I would say 5 o'clock, but I don't know what the travel time is to the Ridgefield Police Department.
5 o'clock works for my client.
Ms. Dowd, does 5 o'clock work for yours?
I believe 5 o'clock will work for my client this weekend. I believe this is her weekend to start work, and she's going to have to find someone to transport the child if her partner cannot.
Okay, I've said the partners are not to do it.
Right. I understand that. Let's go with 5 o'clock, and if there's a problem, I can contact Ms. Powers. I think my client's mother may be able to transport the child, or perhaps her father. We're going to have to sort that out.
Okay. All right, so like I said, I will go ahead and fill out the order for our guardian ad litem. They don't seem to be get done as quickly as needed, so that's why I'm doing it. So I'll get that done. And like I said, counsel, if you can just contact the court administration to get her contact information. I think it may be on our website too.
I believe I have Ms. Schaefer's contact information. We'll take care of that today.
Okay. And then can we set the rest of the orders for presentation on May 28th?
That would work.
I can do that. Your Honor, I do have one last question, and it's a very small thing. My client would like, if possible, to coordinate the time that Cohen is in her household with the time that his 6-year-old sister is there. I understand that immediate parenting time is being ordered for Mr. Sewell, but if it's possible, and I'm not saying that it will be, but if it's possible that we can work out in the first couple of weeks an adjustment to the schedule that will let them coordinate with the child, would the court allow that? Or do you want to wait for Ms.
You can work things out with Ms. Powers if you can.
Okay.
But I want to have no contact between the parties and figure out and minimize the time. But if there's any withholding by either party, you better understand the court will take that very seriously.
Understood, Your Honor.
Thank you.
Anyone else appearing on this matter? Okay, go ahead, counsel.
Thank you, Your Honor. For the record, I'm Georgia Petrie representing Joshua Joyner. It does not appear that opposing party is necessarily objecting to our request. However, it does appear that she wants to attempt to continue to delay. As Your Honor probably read in your review, my client has attempted numerous times to find a reunification counselor, but due to licensing across state lines and those issues, he has been unsuccessful for quite some time. So I understand that mom is very concerned and wants us to go slowly. And I don't necessarily have an objection to the child's therapist preparing her, but I don't think it's going to take more than one session to do so. Olivia is 14. She is not a vulnerable young child. She's able to, she's at an age now where she should be rather tech savvy and be able to terminate a call or express herself if she feels uncomfortable or pressured. So, we're dealing with a teenager here, and we don't really know what she wants. We don't know except for what mom is telling us, which, we have to take with a grain of salt. We don't know what she really wants. Maybe she does want to get to know her dad. And what we're asking for is not unreasonable. It's phone contact. And once phone contact is established, maybe some FaceTime calls. He's not asking for anything more than that. So I don't think this is an unreasonable request. We had to bring it to the court because I wasn't getting any kind of response from opposing party or opposing counsel. And we needed an answer. My client is tired of delaying. We've been trying. I even did some research myself, tried to reach out to a few therapists, and I was met with the same barriers. He is not in San Diego by choice. He is active career military. You know, this is where he's stationed for now, and he may be stationed somewhere else. All the more reason to establish some kind of phone or electronic contact between father and daughter and let them start communicating and building a relationship. Let her get to know her dad. And I just don't see any reason for further delay.
Ms. Bliss?
Thank you, Your Honor. For the record, Carly Bliss on behalf of Ms. Joyner. The court in this matter ordered reunification counseling in November of 2022. We're a year and a half later. Now I understand that due to the different states, there's different licensing issues and reunification isn't appropriate in this matter. That said, the court had concerns regarding the lack of emotional ties between Olivia and her father. That's why reunification counseling was entered back in 2022. Those concerns have not changed. Those concerns are very much still in existence. It's been a year and a half since then with no contact. Olivia hasn't had any contact with her dad since 2018. So we're going on 6 years. A 14-year-old hasn't had contact with her father. And prior to that, my client provides the contact was sporadic. My client's not saying that Mr. shouldn't have any sort of communication with the child. We're just asking the court to order that that be at her counselor's recommendation. My client provides for the court that she hasn't involved Olivia in any of these communications because that was the recommendation of Dr. Altig. Dr. Altig specifically said, given the history of the parties, don't tell her that this is starting unless it's actually starting. So my client has abided by the doctor's recommendations and has not included Olivia in these communications. My client agrees that if Olivia begins these communications and they go well, that naturally they can progress. But my client's concern is the fact that we do have a teenage girl. Who has relatively no emotional ties with her father, who has not had any sort of communication with her father in a substantial period of time, being forced to engage in telephonic contact or forced to engage in FaceTime contact without having a safe space to work through big emotions that are naturally going to occur. My client's simply asking that Olivia be permitted to attend some counseling to work through this. I have no objection to, obviously, the recommendation of the counselor is going to be the recommendation of the counselor. If it does take one session and the counselor says, let's start phone calls, well, then we'll start phone calls. But I think that that's going to be more appropriate coming from a provider who has the skill and the ability to help her work through these big emotions to avoid any sort of catastrophic reaction. And that's what my client's major concern is the fact that if there is no protective barrier of a safe space to talk about these things, that there may be some sort of catastrophic reaction. Like I said, if it takes one session, it takes one session. But I think we obviously need to start there, not jumping into the deep end before we know how to swim. So that's my client's request, is that communications essentially begin at the recommendation of Olivia's individual counselor. Since we can't do reunification counseling, this is naturally the next step.
Ms. Bliss, I just need to ask, has she started counseling already? I wasn't real sure.
No.
Okay. All right. Ms. Petrie?
So, Your Honor, I understand and I can agree with some of the positions of Mom. I would not say that she has no ties. She has limited ties. Clearly, if she's 14 and the last contact was 2018, she must have some memory of him. She must remember him at some point. She clearly had some contact with him before. So, you know, this isn't a stranger or someone she's never known, never met. This is someone that she knows is her dad. And maybe she has some words for him and maybe she needs that opportunity to get them out. You know, and that's okay too. Talking about a safe space. Well, isn't the child's bedroom probably one of the safest spaces that we could find for her to have a conversation with her dad, even if it's just texting? You know, and we could even arrange it so that she has a therapy appointment the very next day or even later that day. Those are some easy things that we can set up. But the problem is there's just been no communication from the other side expressing a willingness to even engage in trying to set something up. So that's why we're here before you today. Because I guess we just need some direction from the court. I'm willing to work with the court. I don't like to give too much authority to counselors, Your Honor, just because they're not lawyers. They don't understand the law. They're meant to treat a patient. So I'm totally happy with, let's get the kid set up with a therapist by such and such a date. Let's know that, you know, the goal of this is to get the kid to prepared and ready to talk to her dad and try to see what happens, and then deal with deal with processing what those conversations entail afterwards through a session. We're totally happy to cooperate with any of those steps, but we just don't want it to be an unnecessarily long delay. So we want some deadlines.
All right. So I have reviewed the files and record, and based on that, we'll be ruling as follow. This is obviously very difficult because we have a child that has not had contact with the father for quite some time. And the court would have preferred the reunification counseling. It doesn't blame anybody. I hadn't even thought about the cross state issues that may have come up. Court would have preferred that, but obviously it's not going to happen. Since that is not going to work, the court is going to intervene and set up a plan for reunification. The mother has requested the child see a counselor first and let them know what she wants. The court can tell you it does not put that kind of pressure on a child in making the final decision, no more than whether a child deciding they will or will not go to see a parent. So the court's not going to be putting that on the child. So with that, with the child not starting counseling, the court wants the child to start counseling immediately. The court will allow that counseling to go on for 1 month. And once that month has passed, so basically we're at the end of May. So by the end of June, so it's a little bit more like 6 weeks, I guess. But I think by the time you actually get a counselor and get in, that may be what it is. So come August,
You mean June, or do you mean end of June? So it would be beginning of July?
Oh, July. So, okay. So we're in May. Sorry. I'm already getting us in August. So looking at, June, so at the beginning of July, I should be saying, the father can start sending letters no more than once a week for now. And I would ask gifts not be sent. Photos are okay, but sending gifts may be misinterpreted or misunderstood by the child. So I would ask that gifts not be sent. The father needs to establish a relationship for a bit. And so letter writing will occur for 1 month. So the month of July. Once that occurs, then texting can start. And you're talking about a 14-year-old. That's how they communicate, texting. And the father should not be surprised if there are no instant responses. This is a 14-year-old. Then after a couple weeks, a video call can be set up. I would encourage the dad to also work with a counselor to help get some direction ahead of time as to how to best interact with this child. See how the video calls go when you have had a month of video calls, 1 per week at an agreed upon time for up to 30 minutes. The mother can be present but not participate for the first call. Thereafter, the mother is not to be present. As to the address of the mother during the letter writing process and texting, it will be kept confidential and an alternative address provided to the father. This is not to penalize the father, but is actually an assurance to the daughter if she feels threatened. Right now, she does not know the father, and once this properly progresses to an in-person visit, then an address for the child shall be provided to the father or where the child resides. As to the 191 factors, only lack of emotional ties will be limiting factor, but otherwise the proposed plan is fine. And one of the family apps should be used for now between the mother and father.
And
then just proceed from there.
Correct.
There we go. I think we have the same question.
I mean, once they start, hopefully having some in-person, those go positive. If you need to bring it back at some time, you certainly can do that.
Okay.
But hopefully it will be positive and things will go well.
All right. Thank you, Your Honor.
All right.
Ms. Petrie, do you think we need to set a presentation date or?
No, I think I can. I took pretty copious notes. I'll try to draft a good order.
Good. Okay. Thank you, Judge.
All right. Thank you. All right. That concludes this docket.